I'm innocent. So let's have a trial.
That's former FBI Director James Comey. He's been indicted for lying to Congress and obstruction, and he wants his trial. A lot of this centers around Comey's willingness to shuttle information to the media to smear Trump and then lie about it when asked.
On May 3rd, 2017, in this committee, Chairman Grassley asked you point blank, quote, "Have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation?" You responded under oath, quote, "Never." He then asked you, quote, "Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration?" You responded again under oath, "No." Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Who's telling the truth?
I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017.
So your testimony is you've never authorized anyone to leak. And Mr. McCabe, if he says contrary, is not telling the truth. Is that correct?
Again, I'm not going to characterize Andy's testimony, but mine is the same today.
We wanted to break down what happens next procedurally, so we're bringing in someone who knows the courtroom well. Michael Parker is the managing partner at M.R. Parker Law, and he joins us. So, Michael, simple indictment, a page and a half. I think that shows the strength of the case. What are your thoughts?
I mean, it does and it doesn't. I think there are some concerns to have about the indictment. So there were actually 3 charges that were filed for the indictment against James Comey. So the third one actually didn't hold up. The grand jury didn't give the third charge to the prosecutor, to the U.S. attorney. The burden of proof for an indictment is fairly low. It's really just probable cause. So it speaks to the weakness of one of the charges, but then it also speaks to the strength of the other ones. Because if the grand jury was willing to let one of them go, they must have felt really strongly about the other 2. Because it's unusual that a grand jury will give some and then not give others. It's usually an all or nothing thing. So I think it does speak to the strength of the remaining 2 counts and the weakness of the third one, which may have been a little bit of overreach. Now, as far as what happens next, Comey's going to turn himself in. He's not going to be held in custody, most likely. He'll be released on his own recognizance, and then he'll be arraigned. And then we'll move forward with the case from there. So, we'll see what happens once it gets in the court. But I think for the 2 remaining charges, there's a lot of strength there.
This isn't state court, it's federal court. Do we get a mugshot here?
I don't think so, not in federal court.
Okay, so... Now, I do want to go over what I believe is kind of an elegance to the charging document, because I think a thrust of the defense will be this political drama playing out in criminal court. And, we had another guest on who noted that when you had the Alvin Bragg prosecution against Trump, the Fani Willis prosecution, that you had all of these different counts and you had these very thick indictments. And after a while, the volume started to look like a substitute for substance. Whereas here, like, the fact presented is pretty binary. The guy lied to Congress about authorizing leaks or he didn't. Do you think that slimming it down limits some of the avenues for those types of selective prosecution defenses?
I've tried a lot of cases. My office has tried a lot of cases. And the simpler you can make it for a jury, the better. There's a phrase, when you're explaining, you're losing. When something's complicated, when it's convoluted, it's really hard to get the jury to follow and to give you that conviction. And in this situation, it's very, very straightforward, right? In 2020, there was a conversation with Ted Cruz at a Senate hearing. He doubled down on his 2017 statement about not knowing whether an anonymous source was authorized to speak to the Wall Street Journal. Clearly, he lied about that. And that's it. It doesn't need more than 2 pages. It's open, shut, easy for a jury to understand. And I think it's not going to be a hard conviction to get. Now, whether he'll get jail time or how hard the judge is going to come down on him, I don't think much. Remember, it's a Biden appointed judge, right? There might be some sort of, negotiated resolution because of that. But I think that the charges aren't going to be hard to prove. I think that it's a very simple, easy, straightforward case for a jury. And the fact that it's so elegant and simple really proves the strength of the case.
What do you think will be the next steps as far as the defense's motion strategy? Obviously, they'll try to do everything they can to avoid a reckoning with a jury.
Yeah, I mean, I just don't think there's a lot they can do. It's so straightforward. There's not a lot of evidence, right? The only evidence is really his testimony in Congress. There's not a lot to get thrown out or challenged. I mean, I think they're going to have to try to negotiate some sort of resolution. And I think that the Trump administration, Pam Bondi, the Department of Justice may do that because the point of this prosecution isn't political retribution. It's to show that whether you're an elected official or not, that you cannot lie in congressional hearings. The point of this is to preserve the integrity of congressional hearings. So the outcome of this case doesn't matter at all. It's the fact that people need to know when they're testifying in front of Congress or the Senate that they need to be honest, that they have to be straightforward, and that they can't hide behind their office and think they can get away with it. So I think the outcome of this is a lot less important than the message it sends, which is we need to uphold the integrity of the congressional process. The Congress needs to be able to investigate things and get the correct and accurate information. And that's really what this is about.
So I started writing down who I thought would be on the government's witness list. Again, I was very involved in all this stuff in 2020 and Comey's activities and was involved in some of his depositions. But
yeah, McCabe, that's who's going to be on there.
Well, right. But that's an interesting little thread to pull, right? So you're going to have Andrew McCabe, you're going to have Peter Baker, some of these upper echelon people at the FBI. And we spent a good part of 2020 and beyond saying these people were liars. They themselves were dishonest to Congress. How do you go about, as the government, putting people up as the key witnesses who a lot of people believe themselves were misleading Congress and the public on these key questions?
I mean, I think you just have to look at context, right? It's like Occam's razor. You know, the simplest explanation is the best one, right? And I think when you look at all the evidence, you look at the context of what happened, it's clear that there was this witch hunt, right, with the Russia investigation against Trump. I think it's clear that it was coming from the FBI, right? You look at all the Carter Page stuff. I mean, you look at how much stuff happened during the 2016 election cycle. I think it makes it easy to put it in context and to see kind of what was going on. And I don't think the fact that, you know, we call people like McCabe a liar during the time matters. I think people know what the narrative is. I think they know what really happened. And I don't think it's going to be hard to point to those people and say, hey, look, they might have credibility issues for certain things, but we believe them here when it comes to Comey, and that Comey knew all about this anonymous source, that Comey gave his assent to it, and that he was involved and lied to Congress when he was speaking to Ted Cruz and also back in 2017.
Witnesses don't typically arrive on the witness stand stepping directly out of sainthood. You get the witnesses you have, not the witnesses you want in all cases. And I've had matters before where you have to deal with a witness who's had prior statements that the jury isn't going to like, that are going to be disproven by other evidence. And there were some who say you deal with that right at the beginning. I always like to start with my best stuff, my most important stuff, my captivating stuff, and then, sort of deal with the fact that, oh, yes, and as an aside, there are these other matters that you want to control and present before cross-examination. Just like generally speaking, how do you deal with that? Do you try to front load what you have to correct with a witness, like potentially an Andrew McCabe, who's got other statements that aren't necessarily aligned with the truth?
Oh, we always put all of our worst evidence in our opening, right? Because you want to control the narrative of how the jury hears it. Because if you don't control the narrative of your bad evidence, then the other side's going to control the narrative of your bad evidence. So every single case I've ever tried, there's at least one piece of bad evidence. And to be quite honest, there's lots of pieces of bad evidence in every single case, right? Even if you have the best plaintiff in the world or the best defendant in the world, and you need to get in front of that. So, what you're saying about strategy is absolutely correct. I tend to do it a little different. I lead with the worst pieces of evidence, and then I let those, get out there, and then I follow up with the best pieces of evidence and leave that in the juror's mind so that when it moves on to the other side, they're left with a good impression. But yeah, you are absolutely correct in terms of getting it, out in front of it and getting it out to the jury on your own terms. And I think it's going to be funny when this also goes to people like Tish James, because I think she's probably going to be next on the list of people they're going after.
Lindsay Halligan got this indictment very quickly. She was appointed as the U.S. Attorney for the Eastern District in this temporary role that allows someone to serve for hundreds of days potentially. But what does that tell you about the grand jury process, that she was able to get in there and activate an indictment on 2 of these 3 charges very quickly? I
mean, I think it just tells you that, number one, the administration has credibility, right? The fact that they were able to get a grand jury to, rubber stamp essentially the first two charges so quickly shows that the administration has credibility. I think it shows that she has more experience than people give her credit for. When Lindsay came in, a lot of people were saying, hey, look, she's never been a prosecutor. She worked in the Trump campaign and, had been there at Mar-a-Lago. But, what experience does she really have? I think she was an insurance defense lawyer before that. And it really shows that she can get in there quickly. She can take control of the situation, that she's a good leader. And I think Trump got the right person in there. And we'll see, what happens down the road. But right now, she seems like a very capable prosecutor, capable leader. And I have a lot of faith that she's going to do a good job.
She seems to get the essence of this case very quickly. And I
yes.
know Lindsay Halligan well. She's brilliant. Anyone who underestimates Lindsay Halligan does so at their own peril. Michael R. Parker, thank you as always. I love getting into the nerdy parts of legal process with you when these stories are in the headlines. I always appreciate it.
Me too. Thanks so much, Matt.